Mr. Allen is here today after failing to appear before this court on March 29th, 2023. For the record, that was a bench warrant hearing. Mr. Allen had he paid $150 on his account to resolve a previous bench warrant. Made that payment on March 1st of 2023. We scheduled a hearing for March 29th, and then he failed to appear for that hearing. Bond is currently set at $514. This is the sixth bench warrant. He reports no employment. Last payment made to this account was that $150 payment. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 19th, 2023 at 8:00 a.m. before this court.
Mr. Allen, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond to assure your tenants at the next hearing on April 19, 2023, 8:00 a.m. You will get notice of that in writing. Mr. Allen, inform me if you would, why did you not appear at the last hearing on March 29?
Actually, Your Honor, I didn't get. I've been going through a lot of things in my life since I've been home from prison, and I don't have no income. I'm trying to get my disability. I got my arm right here.
Okay, sir, none of this explains why you didn't show up for the hearing.
Okay, I didn't.
You're just talking is what you're saying. Because at the time we would have done our prior bond review hearing, I would have informed you of when that hearing date was, which like I did today, I'm informing you the next hearing date is the 4/19/2023 at 8:00 a.m. So you didn't have to get any paperwork in writing because I informed you of that. So, well, court will note it is your sixth bench warrant, and again, you didn't appear at the last hearing. So the court is going to continue the bond in the amount of $514. If you're able to post that, you'd be able to be released. Do you have any questions, sir?
Yes, sir.
Okay.
I'm sorry.
Thank you, sir. The court will end this matter at 8:35 a.m. You're free to go.
Johnson is here today after failing to appear before referee Snyder on February 7th, 2023. Bond is currently set at $1,843. This is the third bench warrant. He reports no employment. Last payment made on this account was in August of 2022. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 19th, 2023 at 8:45 a.m. before this court.
Thank you. Mr. Dotton, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on April 19, 2023 at 8:45 a.m. Are you able to post a bond, sir?
I got maybe like $100.
Okay. Well, in view of the amount of the arrearage that's owed in this matter, the fact that again that you didn't appear at that hearing in February of this year, and again haven't made payments considerable period of time, I can't do it for that minimal amount. What the court will do? Go ahead.
I was incarcerated quite a bit. And
Okay.
then I had just gotten out, and I just had a job interview at Stewart Sutherland in Vicksburg, and I was going to be going to an orientation. It was tomorrow, as a matter of fact, Tuesday.
Okay. Well, what I'm going to do is I am going to set your bond in this matter in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay. Thank you. We'll end this matter at 8:40 a.m. You're free to go.
Adams is here today after failing to appear before referee Cruteau on August 18th, 2022. Bond is currently set at $500. This is the third bench warrant. He reports no employment. The last payment made on this account was in September of 2021. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on April 19th, 2023 at 8:00 a.m. before this court.
Thank you. Mr. Ives, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on April 19, 2023 at 8:00 a.m. Are you able to post a bond, sir?
I have no way of getting a hold of my mom or dad right now.
Okay. Okay. Well, what I'm going to do is I don't know, it's again, your third bench warrant. You haven't made payments in over a year and a half. So I'm taking that into consideration. What I'm going to do, but I will reduce your bond. I'm going to set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
I think I have $100 on me. If I could get a hold of my mom, I could probably get the other.
Okay.
100.
Okay, well, try to get a hold of her then. Thank you. Court will end this matter at 8:42 a.m.
Is here
You're free
today
to go.
after failing to appear before referee Croteau on May 19th, 2022. In the first case, bond is currently set at $500. In the second case, bond is currently $2,989. This is the sixth bench warrant in each case. He reports that he is employed at McGann Motorsports. Last payment made on these accounts was in September of 2020. Front of the court recommends that reasonable bonds be set in each of these matters and they be scheduled for hearing on April 19th, 2023 at 8:45 a.m. before this court.
Thank you. Mr. Coy, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on April 19, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond in this matter, sir?
No,
Okay.
I mean.
Okay. Well, what I'm going to do is I am going to reduce your bond. In the first case, I'm going to set your bond in the amount of $100. And in the 04 case, I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
Could you drop the 04 one down a little more, please?
No, not, I mean, you owe a considerable amount in that case, so I can't reduce the bond any more than that. Thank
I
you.
got my son living with me.
Thank you, sir. Court will end this matter at 8:44 a.m. You're free to go. Court will note the appearance of Ms. Kirkpatrick on behalf of the defendant. This matter is before the court on the defendant's motion to amend custody, parenting time, etc. Ms. Kirkpatrick.
Yes, Your Honor. I did file this motion on behalf of the defendant, Morgan Mattingly now. So the parties have one minor child and they have had a lot of problems since entry of the judgment of divorce. Part of the problem is that the judgment of divorce isn't very particular about dates and times and things like that for the parenting time, and it is that way partially because it was done by default and copies the terms of a temporary order that was done about 6 months prior to entry of the judgment. The judgment of divorce gives my client 2 overnights per week, and they are supposed to be done on days when she does not have to work in the evening. And so the judgment of divorce says that she will have 2 overnights per week when she's not working from 6 p.m. to 8 a.m. These may be consecutive days. Well, even though the idea was that she would have overnights when she was home and available, because she does work at the Firekeepers Casino and at sometimes does work in the evening and has worked overnight in the past. The plaintiff takes that situation as saying that she's not allowed to have parenting time until 6 p.m. On the Tuesday. So my client doesn't work at all on Tuesdays, and the father puts the child at his mother's home for daycare because he is working. And then my client is not allowed to come until 6 p.m. to pick up the child. Several weeks ago, he indicated that she could come at 11 a.m. and pick up the child, but then he said he wanted the child back at 5 p.m. and so to bring back to his folks' house at 5 p.m. and then she could pick him back up at 6 p.m. and start the parenting time. And so this has become very problematic. You know, she could have him an entire day instead of her parents, his parents on those days. And this will continue to become a problem when he goes to school in the fall. Another issue is that there has been another personal protection order entered within the last 3 weeks against the defendant. He doesn't like to communicate by the app close as the order requires, but he will if my client insists upon it, and he will hours and hours and hours of questions about her life. And I need to know where the child is on all occasions. And I need to know where you're going. And I have your address before she gave it out and things like that. And all reliant on the terms of the judgment indicating that he's the sole custodial parent. And again, going back to the fact that this was a default situation. And so there are other issues concerning the dates and the times for the parenting time, but there's no ability for them to be able to work together. He doesn't want my client to help out with taking to doctor's appointments, dentist appointments, and things like that, unless he particularly wants it to happen. But the issue about completely controlling what happens during the day is something that is a continuous problem between these parties. And if he's unwilling to agree to make amendments, I'd ask this court that the matter be for evidentiary hearing.
Okay. Ms. Kirkpatrick, you said that she could have the child during the day on Tuesday.
Right.
Presumably, the other day that she would have her overnight, she couldn't have the child. Is that?
Well, for the most part, once she's got them, she's got them. But
okay. That doesn't answer the question, because you said on the Tuesday she doesn't work, so she could have the child again longer during the day. But you haven't said on the second day whether she's working and couldn't have the child other than at 6 o'clock.
She is not working, and she could have the child during the day.
Okay, on the second day as well.
Right.
Okay.
Right. She tries to work more weekends over at the casino. They tend to be, higher paying times for her job.
Okay, Mr. Parsons, tell me what's the problem with her having the child longer on the days that she would be able to have overnights?
There's been times where I've let her have the child earlier in the day. And
okay, that's not the question I asked you. The question was, why wouldn't that work out on the days that she has overnights, that she would have the child longer? You apparently had allowed her to have the child at 11 a.m. on those days, but then had some convoluted thing about bringing back at 5 and taking at 6. So why couldn't she have the child during the entire day?
For me, it's an issue with her responsibility with my child.
Okay, well, anything else you'd like to say, Mr. Parson?
No.
Okay. Well, what the court's going to do is the court will extend that time on the days that she has overnight. She will allow her to pick up the child at 11 o'clock a.m. on those particular days, and then have the child until 8 o'clock a.m. the following day. As obviously it's better that the child be with one of the parents as opposed to another third party. There was some dispute on the parties using the app close. Apparently in the judgment, it says that the parties will use the app close app to communicate. So the court is simply going to enforce what's already in that particular judgment, order that the parties would communicate through that. I do note that there is a PPO apparently in place, but the court would again allow the parties to communicate through that app close, and that would not be a violation of the PPO as long as it pertained only to issues concerning the child. Okay. Ms. Kirkpatrick, I'll ask that you would prepare an order, submit under 7-day notice of entry that would confirm that particular ruling. Court will note the appearance of Mr.
thank you,
Todd
sir.
on behalf of the plaintiff and
Thank
Mr.
you. The
Oakman
court will
on behalf
conclude
of
this
the
matter.
defendant. This matter is before the court. Excuse me. Matters before the court on the defendant's motion for temporary order as well as psychological evaluation. Ms. Ootman.
Yes, Your Honor, as we filed, my client has not had any contact with the minor children. The parties have 4 minor children, roughly aging from about 7 years old to 1 year old. And he has not seen those children since November, since the parties separated. In November, there was an alleged domestic violence incident. Mr. Orand has pled guilty to that and is seeking this court to order a temporary order to provide him with some interaction with these children, which he hasn't seen in 6 months. He is willing to jump through hoops as the court deems appropriate, but is concerned for the safety of the children in plaintiff's care, sole care, and wants to be able to ensure that he can visit them and he can speak with them. They do have a no contact order. He is requesting that communications be allowed through the use of a communications app such as AppClose or Our Family Wizard, and that there's a carve out put into place for the purposes of sole communication about the children. As far as the evaluation, yes, we are requesting that the parties have a custody and parenting time evaluation to help us with a determination on what is actually in the best interests of these children, as the facts are disputed on both sides, to my understanding.
Okay, Mr. Todd, I have reviewed your answer. Anything else you'd like to add?
Your Honor, I guess just for reiteration, a little bit, it's been 6 months, and again, one of the children is 1 year old. That's a substantial amount of time for a 1 year old. And given the CPS history and the lack of ownership in plaintiff doing what he actually did, which was almost kill my client with a frying pan, we believe at this point compliance with CPS safety plan and services, as well as AA, should be required, and parenting time classes should be required before the court has any reintegration. Also, something that's not contained within my answer is that the criminal case itself has specific indications for any contact, and we would just request that those remain in place per the criminal case. We don't believe contact is appropriate until Mr. Ond has actually complied with CPS services.
Okay. Well, what the court's going to do is initially what the court will do is the court will grant to the plaintiff temporary custody in this matter, support pursuant to the support guidelines. The court would provide some, some limited reintegration of parenting time in this matter. The court will first provide that on alternating Saturdays from 12 o'clock noon till 5 o'clock p.m. That will continue for a period of 2 months. Thereafter, the court would grant it the parenting time on alternating weekends on both Saturday and Sunday from 12 o'clock noon to 5 o'clock p.m. in this particular matter. So that will continue at that point for another 2 months. So that puts us 4 months in. The court would then go at that point and provide for standard parenting time, provided that everything is going well. If not, then you can bring a motion and bring it back in before the court prior to that time. Court would order that the parties would communicate through either Our Family Wizard or AppClose, whichever it may be, that they would only communicate as it relates to matters concerning the children. There would be no extraneous communication in that, again, in those exchanges. The court does not find a sufficient basis at this point for a psychological evaluation. Court would order that the defendant in this matter would not consume any alcohol during the time that he'd have the children in his care. With that, I'll ask Ms. Ootman, I guess I'll ask that you would prepare that order, submit it under a 7-day notice.
Very good, Your Honor, I will do that.
Thank you. The court will conclude this matter at 9:17 a.m. The plaintiff and again, Ms. Kapture on behalf of the defendant. In this particular case, the court does note there are 2 matters before the court today: the plaintiff's motion to compel discovery and defendant's objection to the ex parte order. in this matter. Ms. Capser, just to clarify, I've read your answer. You state initially that in response that he did not transfer that $23,725 out of the account, but in answer to paragraph 2, you state that he did move that money from that account so as to not overdraft another account. So I guess it seems like a contradiction. Why are you contradicting yourself?
Your Honor, paragraph 2 is a little unclear. What I meant to say is that he only transferred a small amount of money to cover any overdraft fees, and those were immediately replenished into the trust account. So there is no money missing from the trust account at this time, and that's on the Exhibit 2 that plaintiff has provided. The date is 2/14 on Exhibit 2, page 1. The amount was transferred $1,900, and on 2/15, $2,000 was transferred back into the trust account.
Okay. Ms. Shadowlands, do you have those records to show that the, again, the money was transferred back?
I do not, Your Honor. There was a cash withdrawal of $10,000 in April, $10,813.55 in cash. I don't have any records that indicate that those funds were returned. And quite frankly, Mr. DuPont's own records, the little of which he has provided me in the form of rent rolls that I've asked for repeatedly, indicate that in October of 22, he was supposed to have $31,000 in that account, and he only had $20,000 in that account. So for him to come to court and say he's not dipping into this trust account is not true. And I don't believe he has returned the full amounts that he has taken out since April of 22 into those accounts, particularly the cash withdrawals.
Ms. Capture, can you address that cash withdrawal?
From April 2022, Your Honor, Mr. DuPont doesn't recall that, so he's looking into it. I will note, however, that the rent rolls change periodically in the respect that the tenants occasionally have to be evicted. So the trust account is not a flat rate at all times. It changes. Sometimes after an eviction, the monies that are saved for a security deposit get put into the operating account as rental costs to pay whatever arrearages that are left from the rentals. Again, these are fluid accounts, Your Honor. These are not just straight, this is the amount of money that should be in here, because these are the amount of renters.
Understand that, but they shouldn't vary. As you shouldn't have withdrawals of close to 24,000 or over 10,000, because presumably there's no tenant that has a security deposit of over $10,000 in those accounts.
Well, Your Honor, there was never a withdrawal of $24,000 at any time. The amount of money that plaintiff is talking about, every highlighted line item are deposits into the account, into the operating account from rental amounts. They have not identified a single withdrawal of $24,000 at any time. The only withdrawal that we could identify in the exhibits that they provided was a withdrawal of $1,900, which again, Mr. DuPont immediately replenished the account.
So Your Honor, if I could address that.
Yes.
Because the defendant has failed to provide us with the documentation and discovery that we've requested, my client's been reduced to trying to determine what's in these accounts and what's moving around from screenshots. And then she was ultimately blocked from having any and all access whatsoever. And so our records, I think, are basically from account 3046, which shows transfers of thousands of dollars into 75 or from 7518 to 3046. And then he transfers them into he's transferred funds into the personal account from the operating account. I mean, Mr. DuPont is not stupid. I mean, he's transferring these monies first into the operating account and then into his personal account. But I have a copy of the non-negotiable withdrawal check from April 5th of 22 in the amount of $10,813.55. that is signed by Mr. DuPont. There's
Your
no
Honor, I can
there.
address
Was
that.
a cash withdrawal.
Okay, Ms. Capture, please address that.
In April 2022 was when this divorce started, around that time period. Ms. DuPont had unilaterally taken about $9,900 out of the operating account. All the funds were removed from that account, and then there was a motion hearing. I was not counsel at that time. I don't know if Ms. Shadowins was counsel at that time. The funds were moved into a separate account. They were held there, and then after the first order on this matter, all of those funds were already returned. So this is an old situation that is not relevant to this immediate motion. Again, with regard to discovery, defendant has provided every single document in his possession and control. Plaintiff has had access to these accounts. The reason she's had access and how we know that is because she provided a printout statement to make this this ex parte motion of hers. For her to say that she has no idea what's going on would again be a material misrepresentation, because as she claims in her statement that she has operated and managed the business, so she should understand how this business operates. Granted, we don't believe she has done any kind of operation because the CPA has done that primarily, and Mr. DuPont's. When Ms. Shadowins states that Mr. DuPont has transferred money into his own personal account, the exhibits that Ms. Shadowins has provided directly contradict that statement. On page 2 of Exhibit 2, these are the documents that they provided. We did not even have to provide any documents because her own exhibits identify the misrepresentation that she's made to the court. On January 23rd, 2023, Mr. DuPont deposited $3,000 of his own personal money into the operating account so as to avoid overdraft fees and to make sure that bills are being paid. He only took $1,000 of that back. He has not taken any additional draws. He actually, the business owes him around $22,000 on paper. So again, we have provided every document that we could possibly provide at this point. This morning, I again supplemented discovery. Again, this goes into plaintiff's motion to compel. We continue to supplement. As I noted in our motion, our answer to the motion to compel, we have not received a single supplemental answer from plaintiff's discovery. And yet we continue to not object to the disclosure of documents through the CPA, even though their subpoena was months beyond the discovery period. We have no issue with providing documents, and we're not hiding anything. Had we had a conversation about this, we would have not been here today. But
That's
instead of
not
having a
true. I have
conversation
sent
and ex parte, excuse
letters.
me.
I've sent numerous letters to both you and Mr. Tolt in regards to these discovery deficiencies, the most recent of which was on Friday.
Okay, go ahead and finish, Ms. Capture.
Again, Your Honor, we continue to supplement. Mr. DuPont is operating a business that takes a lot of paperwork. There are a ton of accounts here. It takes time to collate all these documents, review them, and send them on. We're doing our absolute best. However, again, we're outside of the discovery period. Eventually, there needs to be a time where there's a cutoff of what we're producing. Instead, we're being bogged down with document production where plaintiff doesn't ever produce any documents. I'm having a difficult time explaining when plaintiff's own exhibits directly contradict every statement in her petition. They even contradict her own statements in her reply to our objection, stating that the properties they pay their own utilities. That's directly contradicted to the exhibits that she's provided, which say Granger Refuse, Consumers Energy, Semco Energy. All of these payments are coming directly out of these accounts. Freezing these accounts is extremely detrimental to the tenants who live in these properties. Not only are the utilities being paid out of these accounts, but also taxes, mortgage, insurance. Mr. DuPont has not benefited in any way from utilizing these accounts. He's not taking monies. Instead, he's having to take out credit card bills to be able to pay his attorney's fees because Ms. DuPont has created such an issue with the banks that he can't even take a line of credit, any kind of draw on his lines of credit. These are blatantly misrepresentations to the court, and we deserve to have some attorney's fees and costs for having to come here and explain again to the court that these are just false statements.
Okay. Well, what the court's going to do in this matter, I know that there have been the requests for discovery. The court's going to order that any and all discovery documents that need to be exchanged will be exchanged within 21 days from today's date. The court will reserve on the attorney fees. The court will, at this point, vacate the ex parte order of 3/28/23, as the court doesn't want to, again, hamper the fact that these parties are operating businesses, et cetera. But the court would order that, in fact, Mr. DuPont would not invade the trust account except as necessary to refund security deposits to the various tenants that may leave or be evicted, et cetera. But that, in fact, the parties would be able to utilize their account simply in the course of normal business in this particular matter. So it looks like we have two orders that Ms. Shadowins, you can provide an order as it relates to the discovery, and Ms. Capture, you can do it as well as it relates to the ex parte order. The court will reserve on attorney fees on both of the matters at that particular point for future determination.
Your Honor, can I add anything additional?
Is there anything besides those two issues that we're addressing?
It has to do with the tampering with the account.
I don't know what you mean by tampering of the account.
I don't know either. And I think what I've said is that takes care of the issue of those accounts. So we'll address it later when we have a trial.
Thank you, Your Honor.
Okay, thank you. Court will end this matter at Ms. McNiff on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. This matter is before the court on the plaintiff's motion for relief from judgment. I have reviewed, again, both of the motion, the answers, as well as other documents in this case. I guess I don't need a reiteration of all of that. I would ask Ms. McNiff, just for clarification, on the flex account balance in this particular matter, you have stated that, again, that your client replenishes that, and you state that, how many more is my number? You state that she does that at a rate of $76.15 bi-weekly, but then you said it's replenished at the beginning of the year. So why would she be making bi-weekly contributions if it's replenished at the beginning of the year?
I didn't explain that well, Your Honor. My understanding is what happens is the credit union replenishes that amount at the beginning of the year and then deducts the amount from her paycheck in order to pay back the credit union for the amount that they replenish at the beginning of the year.
Okay. Ms. Thomas, addressing that, you reference Exhibit A, page 7, which shows the balance of $19.99. And that would be, is that the balance after the first of the year? Or is that the balance as of the 12/29 date?
Well, this is, that is the plaintiff's, the plaintiff's exhibit. And in looking at that exhibit just by itself, I see where they have their number, but that is deposits paid, but it shows where it shows the actual on page 7, it shows on their exhibit the plan balance of $19.99.90. So in the time frame of that is 1/1/2022 to 12/31/2022. So if it's to 12/20 or 12/31/2022, which is 2 days after that 12/29 date, if the plan balance is $19.99.90, then that's the plan balance. This is their exhibit. This is what it says, and I can only read what their exhibit is.
Okay, Ms. McNiff, how do you respond to that?
Your Honor, Ms. Thomas subpoenaed all of the documents for Mrs. Miller's financial information from the credit union. She does have, in fact, the information as to what the flex plan balance was at the end of the year. Like I said, it replenishes on the first of the year. So she's taking the highest amount possible. And we would point out also that Mr. Miller had access to that account throughout 2022 and did in fact use it for his medical expenses. However, we're asking the court simply to take it at the end of the year,
which was what the court ordered us to look at, where balances as of 12/29.
Okay. Well, the court, I guess I don't know how we're going to resolve this because the court did rule that that would be taken as of 12/29/21. I don't want to include any, I guess, after contributed amounts, but apparently the two of you continue to argue about what that amount is. So all I can say is we're going to take the amount as of 12/29/21, and that will be the amount that's included. So if you can get additional documents to clarify that, then again, that's what will be done in this matter. If not, then we'll be left with, unfortunately, where we're at. I'll address the issue, the mortgage and the home equity. I do believe that Ms. Thomas was correct in that particular amount. I previously ruled in this matter that she would not be reimbursed for the mortgage and the home equity because she was in the home. And I think we addressed that previously when we clarified that earlier this year, I think in March, when the court reiterated that again, March 27, 22 hearings. So again, the court is not going to, in fact, allow her to have any credit for those particular payments because she remained in the premises. On the issue of the paid time off, the court did note that that was the total paid time off was $31,050, stating that the defendant was entitled to $15,525 and that could be utilized as a credit or set off in that particular matter. So that is the ruling on that particular issue. Likewise, what happens is the court on the Kellogg stock that in the amount of $30,842.03, that was again a set off as well, notwithstanding the fact that he has to transfer that, but the amount would be set off against the amounts that the parties are paying back and forth in this matter. As it relates to the
Your Honor, can I interrupt just for a second on the Kellogg stock? My objection was that it's a post-tax asset, and it seemed to me that Attorney Thomas was setting it off against pre-tax assets, and I was asking that it be brought up to be set off against assets like the house and the vehicles and things like that, rather than against retirement accounts.
Okay. Well, that was the intent with the set off, was to have it set off against current, current accounts in this particular matter. So the court does not have an issue with doing that and having that offset against those other particular assets and payoffs. But
Your Honor, if I can, the way that the chart is set up that's attached to the judgment of divorce, I simply have that Mr. Miller is going to receive that amount. And I don't actually have it as a set off. I mean, it can be a set off when we go back and forth about who's going to get this and that and whatever, but I don't have it set off any pre or post. I simply have it in his column that he's going to get that. The reason that I did that one separate is because both that and the Baird brokerage account, the large one, both of those are in the trust. And so because they're both trust assets, I did keep those separate because we have to do those differently than we can anything else because they have to be pulled from the trust. And the stocks, for example, if they have to be changed the name of them. I mean, there's a process. And so I simply put that he's getting that. And when I do the total, that he's getting it, but that one really wasn't so much a setup as it's just, we know he's getting that much. That's fine. But there's a process to that, which is not with anything else because we have to transfer them from the trust to him. It takes some steps there.
I don't have a problem with that, provided that the plaintiff does get credit for that particular amount of money.
For half of it.
At some
Right.
point.
Right.
Okay.
Sure. Yeah.
Okay. With that, the court would note too, in this matter, that there was the issue brought up by Ms. McNiff about the payoff on the house. As I stated, I gave the defendant 180 days to refinance. So the court, again, would be the intent was that obviously the payoff of the plaintiff would correlate to that refinance, because typically that's how you'd have to do it, is you'd have to refinance it, then you'd pay off the other party. So the court would order that $211,370.49 would be paid to her at the end of that, or within that 180-day period. Court would note the next issue on the Omni account. Obviously, that was a premarital, and I know, Ms. Thomas, in your answer, you acknowledged it was premarital. It's solely the plaintiff's, and as a result, the court doesn't believe that should be a set off or even in the calculation as a set off because it's her premarital and it's a separate account. So the Omni should be excluded from, again, the account that when it's rolled into the Kellogg's account in this particular matter.
So does that mean the court doesn't want us to apply a coverture fraction to Mrs. Miller's 401k with KCCU?
No, I don't want it applied as it relates to the Omni monies. The other one, as it relates to her other accounts at Kellogg, would be appropriate, that there would be a coverture factor, but not, you have to exclude the Omni amount or the Omni time, the Omni balance, and then calculate it at that particular time. The other issue is was brought up by Ms. McNiff as it relates to saying we shouldn't exclude the Wells Fargo. There was no evidence, again, that it was premarital. Ms. Thomas had responded and said, no, what happens is they did not exclude the Baird because they could not, in fact, do that. So that was all included, but the Wells Fargo SEP account was separate. The court would note there was evidence. There was testimony that was credible in this particular matter, which would, in fact, exclude the Wells Fargo. And the court states the plaintiff did not provide any evidence that we shouldn't exclude that as premarital. So that's, I guess, the issue you get into is you say, well, you haven't provided any documentation that you should. And they're saying, well, you haven't produced documentation we shouldn't, but the court did find that testimony to be credible. So I am going to continue to exclude that. I think that resolves all the issues that you brought up, Ms. McNiff, unless I've missed any.
The one other issue, Your Honor, was whether or not to set off the pre-tax assets against one another or whether to divide them. My concern there is that any increases or decreases as a result of changes in the stock market aren't going to be consistent because all of the accounts don't have the same shares of stock. They're invested differently. So the only way in my mind to do that fairly is to divide each one of those pre-tax accounts rather than set them off.
Okay, Ms. Thomas, why could we not do that? I know it's more time, more expense to do it through a quadro, but why would we not do that if, again, not knowing what gains and losses might be on those accounts?
Your Honor, typically, as we do in almost every divorce case, we add the ones together and then separate whatever one is the larger to divide it into the other one. That's typically how we do it. That's what I did it in this particular matter. I had no reason to believe that it wouldn't be done the standard way that we would normally do this. Although each one is definitely a separate account and we can divide each and every one. It's interesting that that's the way we want it to be done because the person dividing it is going to be Mr. Miller and all the expense related to that will be Mr. Miller because these accounts are Mrs. Miller's accounts. So again, we believe it's increasing attorney fees for no good reason. Again, and there's no reason to do that. It can be done, but the set off way of doing it is the most commonly done, most commonly used here in this county, but not just here. It's the most commonly done way to do it is just, this is the total, this is how much there's plus and minus on that amount of money. And then we go from there.
Okay.
I have to do quadros as well. Mr. Miller does have accounts. So it's going to be, they're going to have to be divided by quadro on both sides.
Yeah. Well, why don't we do that just so that obviously we don't have this issue continuing to rear its head, is we'll just order that those retirement accounts would be divided pursuant to qualified domestic relations order. That way we don't have any issues or disputes as to, again, the gains or losses or anything on those particular accounts. With that, I think that is the final issue. I'll ask that each of you would, I guess, draft respective orders, or maybe because it is your motion, Ms. Knipp, why don't you draft the order consistent with the ruling today, and then Ms. Thomas can object if there's an objection.
Is there any way we can ask that before we file it and whatever, that we can have a copy of it, and which would lead to maybe conversation and about these things, as opposed to simply again being in front of court, again being in front of the court. I mean,
Ms.
the only thing
McNiff,
is,
Ms. McNiff, if you would submit that to Ms. Thomas, at least 7 days prior to noticing it up for entry, then we don't have, again, hopefully don't have that particular issue raise its head. Okay,
Is there any, could I have like 14 days rather than 7 days in that case to notice it? So I don't have to notice it for entry. I could just submit.
okay. Well, do it 14 days. That just gives her more time to respond. So court will do that. The court will end this matter at 9:52 a.m. Mr. Bartel, on behalf of the defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, and exclusive possession of the home. Ms. McNiff.
Your Honor, as the court can see from our pleadings, our position is that Mr. Clifton has a long history of serious and significant alcohol abuse. He's been in rehab twice. He's been in sobriety court. Those failed. This last time we hope will take. However, given the past history of Mr. Clifton not being able to maintain sobriety for any long period of time, we have to take a wait and see approach. In the meantime, it's very difficult for my client to reside in the home with him. The tension and the stress and the conflict is high. We were asking for exclusive use of the house. We believe that Mr. Clifton can find suitable housing with a relative or somewhere else, find an apartment. But we believe that at this point it makes sense for the parties to separate. With regard to the children, Mr. Clifton has not been an involved father at all, regardless of the allegations in the answer to our motion. He has not been the one to dress the children and bathe the children and get them to school and get them to daycare. When he's not been working, the children have still continued to go to daycare. While it is true my client has left the children in his care since he's been back from rehab, it's been for very short periods of time. When she goes to the gym for an hour, when she goes grocery shopping for an hour, for these very short periods of time, she does allow him to take care of the children. She doesn't believe that at this point, newly out of rehab, that he's likely to drink in an hour that she's gone away from the children. But any longer than that, and she has serious concerns, one about his ability to handle the children, about his emotional and verbal abuse of the children, and she's also concerned that he may continue to drink. The court may note that while Mr. Clifton is going to counseling, he's only going to counseling once per week. Typically, when people have alcohol addiction to the point that they have to be hospitalized and have to go to rehab, they are in partial programs, or they go to AA once a day, or sometimes even twice a day, in order to make sure that they don't relapse and begin drinking again. We don't believe that the one counseling session per week, given the longevity and the seriousness of Mr. Clifton's drinking problem, is going to be sufficient whatsoever. So at this point, we are asking for temporary sole legal and physical custody of the children. We're asking that parenting time be supervised by Mr. Clifton's cousin, Jordan Valentine, who lives nearby, who has children herself. We believe that she would be an appropriate person. She's his relative, but we believe that she would be appropriate to supervise that parenting time. We're certainly asking for exclusive use of the marital home and for child support consistent with the Michigan child support formula.
Okay, thank you. Mr. Bartel?
All right, thank you, Your Honor. My client does not deny that he is a recovering alcoholic, and that's going to be with him for the rest of his life. I guess to address the point that he needs to be in more intensive therapy, I guess with all due respect to plaintiff, she is not in the position to indicate how long or what he needs. My client has actually seen Mr. Hamilton through Oakland Hospital, and he's suggesting actually every other week is now good for my client to see him. So it has to be more intensive than once per week is actually inaccurate. My client has received help in the past. The difference now is twofold, Your Honor. Number one, my client thought in the past that he could have a beer or two after a period of time and that would be all right. He realizes now that he is of a nature that he can only, he has to abstain completely from alcohol. He cannot even have one drink. He recognizes that. That's the difference between now and before. And the second is that he does have the help of Mr. Hamilton, which he did not have the help of anyone before. It's interesting that plaintiff indicates that my client was not involved at all with the children, paints this rosy picture from her end that he has not been involved, but she also indicates that he has not worked a lot. If she was the full-time earner, she went to work, she works out, and she's gone all day, who were the children with? They were not always at Little Lambs, which is the daycare provider. They were with my client. My client actually is heavily involved with the minor children, especially the eldest one. The eldest one is taking this extremely hard because she wants to be with my client, and she's fearful she's going to be ripped away from my client. They have a very strong bond. My client, especially since November of 2022, has primarily been taking care of the minor children because their business actually was sold by plaintiff. She was the sole owner of the business. My client ran it with the help of plaintiff, but she sold it. My client doesn't know the purchase price. She doesn't know who it was sold to. There's things that needs to be done with that. So he had been at home by agreement of the parties that he would stay home and he would get a new job that come this spring, which he has just recently got a new job. But he's primarily taking care of the minor children. So she can't have it both ways, saying that my client is not involved, but she's also not involved either, I guess. It's interesting, since my client has been home of recent, the last month, my client has been primarily taking care of the minor children, including during spring break. It's interesting. The thing I would note here, Your Honor, is that either plaintiff did not care about the safety of the minor children, and now she's claiming that she did during that period of time, or, which I think is the more likely event here, is that she did not have any concerns about the safety of the minor children with my client, but she's only doing so now to try to get the upper hand in this particular matter. She has a history of lying. She has a history of control with my client. She's controlled the finances. She even told my client she did not have to appear. My client did not have to appear today, that I filed a motion that he didn't have to come here today. That's just by way of example to show what length she's trying to go to try to make my client look bad. And the story that she's trying to put forward with this court is not accurate. Your Honor, even her description of how much she's driven the kids around and stuff has not been accurate. My client's mother has always dropped off the minor children in the morning to school, and she picked them up at the end of the day, go home, and then she'd go work out and leave. Here, Your Honor, my client has, though, been heavily involved, is the long and short of this case. We're asking for the remaining, for the status quo to remain. There has been no allegations that the minor children have been neglected, that they've been physically harmed, that my client verbally abuses them. None of that is in there, Your Honor. In fact, it's always been a good relationship between my client and the minor children. And the last thing I would note for the court is the plaintiff in this matter, she's had 2 OWIs. One was dismissed. She has a conviction herself if she wants to point the deficiencies of my client. And as of recent, we had even put in our motion, she had, or our answer to the motion is she herself, when one of the minor children was really sick, she decides to go to a birthday party for 7 hours. She comes home highly intoxicated. Yeah, my client was there to take care of 3 children, including one that's really sick. So we would just ask for the status quo to continue forward, either in the house, or if the court believes my client has to leave, then week on, week off.
Okay. Well, what the court's going to do on a temporary basis in this matter, the court is going to grant to the plaintiff the temporary custody of the children. Court would order support consistent with the guidelines and the formula, and the defendant shall disclose his income to the plaintiff within 7 days of today's date. Well, to the defendant, I say, to Ms. McNiff's office, so she has the income, because Mr. Bartella stated he did begin working on April 3rd, 2023, so he should have a paycheck stub that he can provide. The court will grant to the defendant standard parenting time, the weekends to go from Friday through Monday morning, as opposed to Sunday, as well as alternating holidays, the breaks, etc. In this matter, the court would grant to the plaintiff exclusive possession of the home, allow the defendant to have 30 days to vacate. The court would order that while the children are in the defendant's care, that he not consume alcohol, either while the time they're in his care or for 4 hours before that, and also order that the defendant would continue with counseling with Mr. Hamilton in this particular matter at the recommendation of Mr. Hamilton. Ms. McNeff, I'll ask that you would prepare that and submit under 7-day notice. And we'll end this matter at Mr. Umlauf, on behalf of the
Go ahead.
plaintiff, Ms. Nickerson, on behalf of defendant. We have two competing motions, the plaintiff's motion to modify custody, parenting time and support, as well as the defendant's motion to modify custody, parenting time and support as well. I have reviewed the answers as well as the motions. Is there anything else, Mr. Umlauf, that you would like to add in this matter?
I'm going to rely on my response and the motion. The only additional things I'd like to add are that paragraph 9 of plaintiff's motion noted that the change she's made in her work schedule is not sustainable long-term, which does beg the question of what is her plan long-term if she intends to have primary custody of the minor child in this case, as far as issues of childcare and things like that we raised in our motion. The other thing I will add is that I've reviewed the minor child's attendance records at school. She has 8 absences with her mother, 4 of which were unexcused. 2 were excused by mom without a reason given. By way of comparison, and this is just this academic year, my client, when the child is with him, she only has 4 absences, all of which were excused with valid medical reasons, for one was an excused absence for his wedding. Thank you.
Okay. Ms. Nickerson, anything else to add?
So my client's employment has changed. It wasn't when the plaintiff had changed kind of what their agreement was. Her employer was able to accommodate that for a period of time, but unfortunately wasn't able to do that long term. So she's now driving for a different company. And so what she's able to do the week on, week off, their last order says 2 weeks on, 2 weeks off, but they haven't been doing that for some time. And so she is able to make that alternate week schedule work. She'll just work more hours in the week. She doesn't have the minor child in her care. And I had said to my client, the motion that Dad filed, it's making it seem like there's an issue with parenting time, but then the request is a change in custody, which I would argue there's not proper cause or a significant change in circumstance to warrant. I also think if what he's saying is true, that he hasn't moved and isn't moving to the Middleville area, although my client's not sure the sincerity of where he's been staying. If he truly isn't moving, then there probably isn't enough of a basis to change custody on her end either. They're going to have to work out some of these issues that I think have come about with his new relationship. The problem is, I suppose, is trying to verify where he's living. And so I'm not sure if the court, if we can resolve that without a hearing, if the court could order Dad to not only notify friend of the court, but also my client of his current address and addresses when they change. And then also my client would still ask to use that app, Close app, because with the new relationship, Dad is refusing to speak with her for the most part. And she was directly, without stepmom also being part of the communication. And then my client was asking for the right of first refusal with parenting time, and for the next person to have the minor child to pick up from the other one. So Dad's now been insisting since this new relationship that they meet at McDonald's, but he's not been the one present for the last couple months, except for one time during those exchanges. So those might be things that need to be addressed in a hearing phase. I tend to hope and believe that Attorney Umlauf and I could work through those things if the court denied the request for change in custody, and perhaps it's more properly suited to a hearing involving parenting time disputes. And if they can't work it out before the hearing, could approach it that way. And I honestly don't know for sure where the child support order is out of. I don't know if it's now in Michigan or not, but they are past the time period where they could have a review of child support anyway without having to motion it. And so as long as my client, or if the court knows and can tell us if we can figure out for sure who is administering that, we could handle the child support that way.
Okay. Mr. Almoff, is there any problem with going to the alternating weeks as opposed to alternating 2 weeks?
Your Honor, I'll ask my client.
Your last occurs says it.
My client would still request an evidentiary hearing on the issues of custody, parenting time, and support, but in the meantime, he is willing to, he will accept a schedule of week on, week off.
Okay. Well, the court will note that the parties have, over the period of time since the original order entered back in 2000, that there were moves, there were changes. The parties were, for the most part, able to work out what those changes were. However, apparently right now they're not in agreement as to what there is. They are agreeable that the parenting time will alternate in weeks, so the court is going to order that at this particular time. Court would order that the parties would exchange income information. So we have some current income information, and apparently I think that the attorneys can clearly calculate and figure out what the support should be at the current time. The court does not believe that there is a sufficient basis to meet the Barca threshold, a change in custody on either party's part. So the court is going to deny that particular request. I think what I'll do is I'll ask Mr. Umlauf, I think your motion was prepared first, so I'll ask that you would prepare the order. Again, reflecting that, the court is not going to order any right of first refusal. I think that is a bad idea, as a tendency to most cases it creates more problems than what it resolves. And so the court won't order that in this matter either. So Mr. Umlauf, you can prepare the order, submit it under 7-day notice of entry. The court will end this matter at 10:15 a.m. You're free to go. Have a read on behalf of the defendant. This matter is before the court on the defendant's motion for temporary custody, parenting time, and support. Ms. Reed, as I look through the paperwork, the pleadings, at no point in the pleadings did it say when the parties separated or where the children have been since separation, and that's obviously important in this matter. When did they separate?
I believe the parties separated towards the end of February, beginning of March, and then the children have been primarily with plaintiff. They were in a separate location that we don't know for like a couple of weeks, but they have been now moved back into the home that the parties were renting from my client's grandmother. I do believe have been there for about a month.
Okay. Anything else you'd like to add, Ms. Reed, to your motion?
Since we filed the motion, my client has had contact with the children. They have been re-enrolled at the Union City schools where my client works, and the children did run to him and were very excited to see him. And we were just requesting that a temporary order be in place so we can have parenting time and joint legal, joint physical custody, that the plaintiff not be able to remove the children from Michigan, and a parenting time app be ordered, like App Close or Talking Parents, so that parties can exclusively talk about child-related issues. And we do have the PPO termination motion next Monday.
Okay. Okay. Ms. Heckman, what's your response?
CPS had removed us from the home on February 10th, and that is when I had told him that I didn't want to be with him anymore. And we were staying in a domestic violence shelter. And we have just recently moved back towards the end of February, beginning of March.
Okay. Anything else?
In the papers, he was saying that I was trying to move out of state without permission from him and stuff, and that is not the case. I've been waiting to talk with you guys about being able to move and everything, and like, I have not been trying to keep the kids from him. I just been doing everything CPS had told me to do.
Okay. Well, the court does note, again, as provided for in the pleadings, that the CPS had substantiated improper supervision against both of the parties in this particular matter. The court will note that, as stated, acknowledged that the children have been with the plaintiff since the separation, other than different times. What the court's going to do is the court will grant to the plaintiff temporary custody in this matter. The court would grant to the defendant standard parenting time, standard parenting time on the weekends to be from Friday through Monday morning at 8:00 a.m. The court will order that Again, the children would continue in the Union City schools during the pendency of this particular matter. Court would order that the parties would communicate through AppClose or Our Family Wizard or some other, I guess you'd say, service that would allow the parties to communicate only regard to child-related matters. So any extraneous matters are not to be addressed through those particular apps. I will let both parties know the court does have access to those. We can get copies of those. So if in fact either party goes off about any other extraneous issues or any matters other than the children, that the court can in fact prohibit that communication then at that particular point. So hopefully you don't, because it would be better that you could communicate during the interim period of time. Court would order support consistent with this particular order for custody and parenting time. And I guess I'll ask Ms. Reed that she would prepare that order. You could submit it under a 7-day notice of entry. And we'll conclude this matter at 10.
One question, Your Honor.
Yeah.
So is it joint legal custody or plaintiff having sole legal custody?
Court will grant joint legal custody in this matter, but physical custody to plaintiff.
And then for child support, it's my understanding that the plaintiff's not currently working, and due to the availability of work in the area, may I impute her with $15 minimum wage for 40 hours a week?
I thought you said that she was working back at the Union City schools.
My client works at the Union City.
Oh, your client does. Okay. Ma'am, you're not working, is that correct?
That's correct. I'm currently a full-time student and I do not have transportation at this point, which I am trying to figure out how to acquire transportation so I can get to work, because I do have a job kind of lined up, because my boss from Clemens, when I worked back there in 2020, he said that I could go in and tell them I'm a rehire and I would have a job.
Okay. Well, what the court will do is the court will impute income at a rate of $15 per hour to the plaintiff. As obviously she could earn that, and as she's just acknowledged, she could go back to Clemens if she wished to do so. So the court will impute that to her for purposes of calculating child support. Ms. Reed, you can prepare that. We'll end this matter at 10:22 a.m. This matter is before the court on the plaintiff's motion to enforce judgment and to show cause. Ms. Reed, receipt of your motion, has again, the listing agreement been signed by the defendant as of this date?
It's my understanding it has not.
Okay. Mr. Whitfield, is that correct? You've not signed the listing agreement?
Yeah, not, well, I've signed my part, but she hasn't signed her part yet.
Okay. Why haven't you signed it? The order of the judgment provided it would be listed within 30 days of the entry of the judgment.
Correct. I needed some time to adequately review the document, as well as see if I was going to, we negotiated if I was going to buy them out or whatnot. But I do agree that it is beneficial for all parties to move forward with getting the document signed to get it on the market.
Okay. Well, what the court's going to do in this matter is order first that the parties would sign all of the listing documents within 7 days of today's date. You understand that's next Monday. If in fact, either of you don't go through and sign those documents, the court could in fact order that the matter would go forward without either of you signing those, et cetera. So with that, what else, Ms. Reed, do you have in this matter?
We're requesting that the plaintiff or the defendant be removed from the house. She's not properly maintaining the house. The realtor doesn't have access to come in and show the house because of when she's working. She's implied that she's going to frustrate that process. And so we're requesting that she move out within 30 days so the property can be photographed and it can be listed.
Okay. Ms. Whitfield, what's your response to that?
That is not true. I have cooperated. I've maintained communication with the realtor, Mike Lerma. I have not provided any obstruction. I've asked him several questions. There's been over 160 messages over the past few months. I feel that it would be unreasonable to have me and our 3.5-year-old daughter vacate from the premise, as I've been steadily trying to prepare to get it ready to move, as well as get ready for viewings. I haven't prevented anyone from coming to the property or taking photos. That hasn't been organized, so that is not true. But I'd be willing to cooperate on whatever means necessary, but as well as keeping what's best in mind for our daughter, Sophia.
Okay. Well, what the court's going to do, the court will order that the defendant would, again, cooperate to make sure that the property is maintained such that it can be shown, and that in fact, the property would be shown at the request of the realtor in this particular matter. If in fact the court determines in the future, Ms. Whitfield, that you're not doing that, you're not maintaining the property so that it can be in its best condition to be shown, or you're obstructing, again, the showings, the court can remove you from the property at that time. But I won't do it at this time. The court would reserve on attorney fees at this particular point, pending further hearing in this matter. I'll ask Ms. Reed that she would prepare the order and submit it to the court under 7-day notice of entry. Court will end this matter at 10:27 a.m. You're free to go. Have a good day. Court will note that this matter is before the court on the plaintiff's motion to set aside the referee recommendation. Court would note there's a lot of allegations in this particular matter. It's my understanding, Ms. Waters, you were at the hearing. Is that correct?
Yes, sir.
Okay. And you've stated you didn't receive notice of that court hearing, but you were at the hearing. So
No, I was saying there was supposedly one back in December. I didn't know about that one.
okay. Well, that's not the issue for today, but in this matter, you have to establish that the referee made a factual or legal error in this matter. It's not just that you disagree with what what the order is. The court understands that people will disagree with that, but you're going to have to establish that the referee made a factual or legal error. So what would that error be?
I just was trying to request that he gets shorter time periods to begin with, and supervised visits, and then just to build the trust back up between him and the child, as well as me too, since he's been absent for 8 months. And when he was involved, he was very was violent, unpredictable, toxic, and he would expose the child to a lot of things he didn't really need to be exposed to. And like I said, he has not been in his life for 8 months, so I don't know what his mental state even is right now. And I mean, I knew that he was going to pretty much do exactly what I said he was going to do, and what I thought he was going to do once he did get some parenting time, in which he only got him the one day, the one court ordered day, and then all the rest of his court ordered days he didn't get them.
Okay, well, I guess that's up to him. It's unfortunate if he doesn't take his time, but notwithstanding that, he did have some parenting time, which he took, and presumably, based on what you said, there were no issues with that.
With what?
With the parenting time that he did take.
Oh, there were issues, Your Honor.
Well, you said that he had parenting time, but he didn't take all the parenting time that he had. You didn't mention that there were any issues with it.
Oh, well, I thought that I wrote it in here.
Well, you might have wrote it. I was asking you now, and you didn't.
Oh, I'm sorry. I'm sorry, Your Honor. I didn't know how much time I had to talk, so I was trying to get key points out. But when the day that he did get him, I believe it was March. It was a Wednesday, the very first Wednesday that he was supposed to get him. He got him. Well, he wasn't even going to go get him, but then I guess he ended up leaving work to go get him.
Doesn't matter what he was going to do. I want to know what happened, not what he was going to do.
So when he got the child, he ended up asking him who was the man that I was in the vehicle with the other day, that he saw the man. He put them all on social media. He sent the child back home starving. He didn't even feed him while he had him and stuff like that. And he told the child that it was my fault that he didn't get to see him, that I kept him away from the child, and that he didn't choose to be absent in his life. And then after that, he didn't come back again, which I knew he was going to do this. He just wanted to question him about and get information out of him. He's done this before in the past.
Okay. Well, in this matter, again, the burden is on the petitioner to establish that the referee made a factual or legal error in this matter. There's been, again, many allegations, but nothing to establish that the referee made such an error in this matter. And as a result, the court can't set aside the order just because one of the parties wants it in this matter. I'm not saying that everything's fine or everything's going to work. It may be a subject of future motions, but at least at this particular point, it doesn't seem that there's any reason to, again, set aside the referee recommendation. So the court will deny the motion in this matter, and that will conclude the case at 10:33 a.m. You're free to go. Have a good day.
Your Honor, I have a question.
Okay.
He told me that he works second shift, so he's the hours, the days and times that you gave him, he's not even able to get the child at this time.
Well, then he's going to have to file a motion to change the times of parenting time. Unless the two of you can agree.
Well, I've been trying to come to an agreement with him for something.
I know, but if you can't, then if you can't agree, then you have to file a motion and bring it back before the court. So again, if his times to have the children are a particular time and he can't do that and he wants the child or whatever, then he's going to have to file a motion to modify it if you can't come to an agreement.
And if he continues to mix the all his scheduled parenting time, then what do I do from there?
You don't have to do anything, then he just misses his parenting time.
Okay.
Okay, thank you. Have a good day. Defendant's motion to set aside referee recommendation in this case. Mr. Felton, you've stated what you want. You said, I want joint custody. You've not stated any error that the referee made as it relates to the custody issue. You've stated as well that you don't make as much income as stated. What is your income per hour?
I don't get paid hourly. I'm self-contracted, so we get paid a weekly. I actually did take a big pay cut over the last couple months because we hired more people onto the team. I only make $650 a week now.
Okay. Well, what's going to happen, what you're going to need to do on that is you're going to need to file a motion for modification of support, because as I looked at the referee's determination, the referee had you making just slightly over $800 a week, but that was based upon, again, the amount apparently that you'd made before. So once that amount changes, then you'll have to file a motion to have that reviewed. Okay.
Yeah, I didn't really understand what I was really doing as far as filing that the objection motion or whatever.
Yep.
They were trying their best to help me at the front of the court.
Okay. Well, file a motion. You can file a motion for modification of support. So that's what you'd want to do. Anything else, sir?
What was I supposed to put down as far as when it came to the joint custody thing? Because what you have to do is you have to show that the referee made a legal or factual error. Well,
let's get something else here. Hold on. What happened?
And based upon your pleadings, I can't see where you've alleged that or anything else. So what's the factual or legal error?
I just seen that it said that she was getting sole custody, and from what the friend of the court was telling me is basically what sole custody means is whenever she would allow me to see them, it has to be like yes or no from her. I was just trying to get like some form of even like.
So you're talking parenting time then?
Yeah.
Okay.
Just like where they could come over and hang out for a couple of days and then go back over there and hang out for a few days.
Okay. Well, what you're going to have to do is that doesn't go to the issue of custody. That goes to the issue of parenting time. You can include that in your motion as well, that a set parenting time schedule would be established. Okay.
Okay.
So that would be things that you would include in your motion.
Yes, sir.
Okay. I don't assume with Ms. Lewis, I haven't granted any relief, so I wouldn't assume you had anything that you had to add in this matter.
I have a lot to add. I don't want to have joint custody.
Okay, ma'am, I've denied his request, so you don't need to add anything because I've denied what he's requested at this point.
Okay.
You may, when he files his motion, you may have a response, and you have a right to respond to that motion when he files it.
Okay.
Okay?
Yep.
Okay, the court will conclude this matter at 10:42 to show cause for the the plaintiff failing to pay the mortgage payment and failing to list the house for sale. Ms. Steinsma, has that house been listed yet?
No, he has still not listed the house for sale.
Okay. Mr. Steinsma, the judgment says that it'll be listed within 30 days from entry of the judgment. Why has it not been listed for sale?
The house was listed for sale, Your Honor. I had put it up for sale by owner. I had some home buyers come and look at it. They made me an offer I could not accept. Put me in touch with a realtor. We had several get-togethers and discussing things that needed to be taken care of and done in order to list the home for sale. Ms. Sipma was not agreeing to our idea of price and wasn't willing to listen for, on a decent price throughout the whole thing.
That is not true.
Okay.
That is not the case at all.
Okay. Tell me what the case is.
The house, the SEV on the house is $86,000.
Okay. Ms. Steinsma, I don't care what the SEV on the house is, okay? SEV doesn't necessarily have any correlation to value sometimes. So
Right.
that in and of itself doesn't mean anything.
Right, but
What I'm looking at is, do you have a realtor, and has the realtor been talking to the both of you as to what the house should be listed for, et cetera?
he has never once ever had me in a meeting with anybody at all, nor has he ever talked to me about a price or selling the house, or has he ever had me meet with anybody.
That is
Ever.
untrue.
That is not untrue, John. You have never once had me meet anybody.
Okay. Well, what the court's going to do in this matter, obviously, there's a lot of disputes here. I'll give you a brief period of time, maybe 30 days to try to work some stuff out. If not, we will schedule a hearing and have a hearing on this particular motion and take evidence, take testimony from realtors or anybody else. And at that time, the court can, again, set a listing price on the property if the two of you can agree. So,
Your Honor.
Yes.
I have a question.
Yep.
I have a land contract on the home right now.
I
That
didn't.
was not what was agreed upon. The house is to put for sale so we can split the profit. Not a land contract, not renters, not any of that. Straight for sale so we can split whatever profit is made and walk our separate ways.
Yeah. Mr. Steinsma, there's nothing in the judgment that says it would be sold on land contract. If so, it'll be listed for sale and sold. You can't unilaterally accept a land contract on this, in this particular case.
Okay. I'm merely trying to do this to make sure that home equity line of credit gets paid every month.
I understand, but you're gonna have to work out something else. Either whoever it is that's buying land contract gonna have to buy it conventional, or you're gonna have to sell it to somebody that can buy it conventionally. Okay, well, again, I'll give you 30 days and then we'll set a trial date after that. And if you can't agree to anything in that time, then we'll come back in and have a hearing and conclude the matter at that point.
And I also never agreed to anybody moving into that house.
Okay,
now
ma'am,
we have
ma'am, I don't
somebody
need
moving
any of that for now, okay? We're gonna
Okay.
have a hearing and we'll address everything at that time.
Yes, sir.
Okay, thank you. We'll end this matter at Magnuson on behalf of the prosecutor's office. The prosecutors filed a motion to correct the uniform child support order in that apparently it misidentified and had the parties switched. Is that the basis of it, Mr. Magnuson?
That is, Your Honor, correct.
Okay, okay. Miss Levine, is there what issue, do you have any problem with switching and correcting the order?
What is I don't even know what's going on. All the paperwork I've been sent, I can't read because it's printed in blue ink.
Okay, well, there's a support order in place that says that the plaintiff, meaning you, are to pay, which is incorrect. It should say that the defendant's to pay. They just had the parties switched is all.
Yeah, that's fine.
Okay. Mr. Rowe, what's your position?
I have provided my half of the ROPA Act, and I am currently waiting for the court date on Monday.
Okay. Mr. Magnuson, do you have any problem in this matter, again, staying the current order pending a ROPA hearing?
Pending the hearing next week, Your Honor?
Yeah.
That's fine.
Okay. What we'll do is we'll just, obviously I'll grant so that it'll be corrected, but just we'll hold up by entering that until the time of the ROPA hearing.
I think that's.
So Your Honor, we'll essentially be sorting out things. We'll sort out things next week.
Yeah, it's the first hearing, so we have to do DNA testing.
Yeah, yep. Yeah, we'll just address it next week then, but you can get it corrected now, set to go, Mr. Magnuson, but we'll wait at this particular point.
Very good, Your Honor.
Okay. Thank you all. We'll end this hearing is before the court on the plaintiff's motion to set aside referee recommendation. The plaintiff has alleged that she did not realize that she was supposed to attend that hearing. And that is the basis for the, again, setting it aside. Is that correct, Ms. Castelline?
That is, and I do apologize for that. I received the investigation in the mail, and it stated that it was recommended that Dylan set up visits through Family and Children's Services, and I thought that was the end of it. I didn't realize that we still had the court hearing on the 3rd. I thought that was just what was happening.
Okay. Well, just because you get a report or anything of that nature, it doesn't mean it's concluded until you get an order saying the matter is concluded.
Yeah, I definitely understand. I do apologize for that.
Yeah,
That
that's
was
fine.
lack of judgment.
Well, I will tell you that just simply because you didn't attend, that's not a basis to set aside a referee order. You have to establish the referee made a factual or legal error, and that is why. And you obviously you haven't alleged that or established that in any way. If in fact you have something that's occurred since that particular time or whatever, you have a basis to. You can always file a motion to modify the order, but you haven't provided the court any basis to set aside the order.
Okay, so I apologize. I'm not sure what exactly I need to do from here. I was just looking to get another hearing in place of the one on March 3rd. I would just like to continue on with trying to get supervised or no visits. Dylan has not shown up. He's shown no consistency. He has not taken his son overnight since 2018. Last year, he threatened our 9-year-old son with calling the police and told our son that the police would drag him out of our house.
Okay, ma'am, I'm not going to get into specifics. You can include all that in a motion if you wish to modify any part of the order. I will tell you the problem you're going to have is that, again, any motion would go from the date of that last hearing. So you have to establish there's a basis to modify it since the last hearing date, which you may have or you may not have. I don't know. But you can file a motion for modification. The court can take it up at that time. Okay?
Okay, I appreciate it.
Okay, thank you, ma'am.
Thank
Court
you.
will end this matter at 10:54 a.m. You're free to go.